Alright guys, here we go. Now we got this thing working. Being I'm no video expert or anything like that. Today we're going to try and show you how to find the intent of the law. Because the intent of the law, the way the law is written, what those words apply to, that decides how the law is to be applied. The judge doesn't get to decide it. It's the way the law is written. And it can't be applied any other way. To do it any other way would be considered a fraud upon the court. And we all know what fraud upon the court means. So with that said, we're going to start out here with this paper that I wrote about the conclusion of the findings and facts on the Indiana Title IX Motor Vehicle Code. Okay? And I always kind of figure it's best to start out with the definitions of the various things so that we know what's what. And here we started out with the definition of what an automobile is, so that we can see if there's a difference between an automobile and a motor vehicle, right? And remember in law that a difference could be something as simple as how that is used, not necessarily based on how it looks or how it moves or any of that. The difference can come down to the use. Okay? And once we start to understand this, we will understand the difference between what they call consumer goods and equipment that's defined in the UCC codes. Alright? Now here we go at 49 U.S. Code 32901 definitions. You see that it says, except as provided in section 32908 of this title, an automobile means a four-wheel vehicle that is propelled by fuel or alternative fuel, manufactured primarily for use on public streets, roads, and highways, and rated at less than 10,000 pounds gross vehicle weight. Now, here we have a clear distinction that it's going to be under 10,000 pounds. And that's the federal definition. Okay? The definition you're going to find in most states, I didn't put a general definition for any one state here because so many of them are vague in their description. Okay? And it says every motor vehicle of a type constructed and used for the transportations of persons for purposes other than for hire or compensation. And it goes on to say this shall include vehicles of the station wagon type, whether the same are called station wagons or ranch wagons, van wagons, except those used for commercial purposes. And you notice that term, except those used for commercial purposes. Suburbans, town and country, or by any other name except when owned and used as a school bus or motor bus by a school district or a religious corporation or society as elsewhere provided by law, right? Because we know there's different regulations for some of these different individuals. And here we can see that this is in direct agreement of the constitutional law stating that automobiles cannot be included in the definition of a motor vehicle as the motor vehicle is commercial in nature. Automobiles are consumer goods. However, it does clearly state an automobile is used for purposes other than for hire or compensation, such as travel, which falls under UCC 9-1091, consumer goods, not equipment, which equals a motor vehicle, which falls under UCC subsection 9-1092. Alright? Consumer goods are described in the UCC and in IC 26-1-9.1-102, subsection 23. Right? And it says consumer goods means goods that are used or bought for use primarily for personal, family, or household purposes. Automobiles purchased for the purpose of transporting buyer to and from his place of employment was consumer goods, as defined in UCC 1091, and that was in Malcott versus Volunteer Finance and Loan Corp. Right? 3 UCC Rep Serve 1035 415. You guys get the point. This ruling came out of Tennessee. Okay? One thing we have to remember is that the people have and retain always a constitutionally protected right to travel in our automobiles. It's an unalienable right that we have. And we can back this up down here with the American Jurisprudence Constitutional Law, Section 329, page 1135, right? And let me fix this right here. And it says the right of a citizen to travel upon public highways and to transport his property thereon by horse-drawn carriage, wagon, or an automobile is not a mere privilege which may be permitted or prohibited at will. Okay, so think about this. The Supreme Court said they had a right to suspend a driver's license. Okay? So if they said they had a right to suspend the driver's license, then the driver's license obviously covers something other than your right to use your own personal automobile on the road. Right? I mean, that's common sense. Because they said right here, it's not a mere privilege. It's a right. So if they want to say that everybody has to have a driver's license, now they've got a problem because they're in conflict with the constitutional law, which means they're in conflict with the Constitution, and they can't have that conflict. Okay? But now you have an understanding here that the constitutional law says you have a right to travel in your own automobile. Okay, now this concept, which is called personal liberty, it's amplified even more when you come down to constitutional law in 16 CJS Constitutional Law, Section 202, page 987, right? And it says personal liberty. Personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. Okay? The right of the citizen to travel upon the public highway and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege, which may be permitted or prohibited at will. Okay, so now we can see there's 2 sections of constitutional law which says they don't have a right to stop us from using our automobiles on the highway. So if they want to require us to have a license, that means that license couldn't be able to be suspended. So the license cannot be applied for what they're saying it's applied for, and which means that if they're lying about the license, there's a good chance they're lying about tags and insurance and all of that. So let's move on and see what else we've got here. We've got another section of American Jurisprudence, which again is constitutional law, and this is American Jurisprudence 2nd, 1964, Volume 16, subsection 359, Elements. And again, it deals with personal liberty. All right? Let me get this fixed here so that you're not, I don't know why this keeps doing this, but I'll figure it out. Okay, personal liberty largely consists of the right of locomotion to go where and when one pleases. We're right back to that we have the right to go wherever we want to go, and there's nothing they can say about it. And that we're supposed to be protected not only in our person, but in our safe conduct. Right? And we're going to reiterate this again with another section of constitutional law, which we looked at earlier, which deals with all of this again. Yeah, I see what was causing that. right? But again, here we go. Personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct without imprisonment or restraint unless by due process of law. Okay? How many of us even know anymore what due process of law is? Okay, this is an important fact, guys, because due process of law only takes place in the courtroom. So if due process of law only takes place in a courtroom, ask yourself what they're doing impounding all these vehicles alongside the road when they're not posing an immediate threat to everybody else. If they've not harmed anybody, if they're not intoxicated where they pose a risk of harming somebody, ask yourself what they're doing impounding all these vehicles, stealing people's property, because that's what it is. Okay? We in America have become ignorant of what our rights are, of what the law is. We've trusted that the people who were handling the law were going to be honest with us and tell us the truth about what applies to who. Right? But the problem that we have here is that these guys, they don't do that. Why? Because they get to fill out a couple of forms that very few people know about. And these are forms 205 and 206, which the judges and them then send back to England to get paid out of what's called a Cesca Trust. And there's lots of information out there on it. You can look it up. At some point, I'm sure we'll make a video about it, right? And I want to make a real quick point here. If the intent of the law is the force of the law, ask yourself, why do we have case law? Because the intent of the law should be all we need. Because it tells how it's supposed to be applied and who it's supposed to be applied to. Okay? This comes down to the judges making a ever more grasp on power in both the state and the federal, because they feel they have a right to dictate to others as to how they should use their property. And here we go in the Supreme Court in Arthur versus Morgan, 112 U.S. 495. Okay. Held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. That means they were classifying an automobile as being the very same as having a horse and carriage. Okay? Did they ever ask the people who were in horse and carriages, did they ever say, hey, you got to license that thing to put it out there on the road? You got to put a tag on it, you got to insure it, you got to do all these things? No. We go to Hillhouse versus United States, 152, right? It was in the Second Circuit, 1907. And they said a soldier's personal automobile is part of his household goods. U.S. versus Bomar. Again, same thing. That was in Texas. Okay? They said, and here, in United States versus Johnson, and you know many of us who've been in court for what they say is unlawful use of our automobiles, say that we don't have, the courts keep telling us that we don't have a right to a jury trial because it's a traffic court. Or at least here where I'm at, that's a regular thing. They just deny you a jury and everything. And that's partially because now whether anybody likes it or not, the truth of the matter is, we here in America are being ruled by a communist kleptocracy called the United States. which again is not what people think it is. It is a corporation, and it is not America. It's a completely separate entity from America. But this communist kleptocracy, and by the way, folks, kleptocracy means ruled by thieves. And if anybody sees anything lately about Hillary Clinton, there's no doubt we're being ruled by thieves. Okay, but they said it was a jury question whether an automobile was a motor vehicle. And that was in the United States versus Johnson. And that took place in Florida. That was the Fifth Circuit. Alright? And it says the use of an automobile determines the automobile's classification in determining whether or not a motorboat was included in the expression household effects matter of Winburn's Will Supra, right? And it said stated the test to be whether the articles are or are not used in or by the household or for the benefit or comfort of the family, right? So here we see and know that this was over whether or not it was just personal use by the family or whether there was some other type of commercial use, right? I mean, that's pretty obvious to figure out. And that was in 1955. It says the use to which an item is put, rather than its physical characteristics, determine whether it should be classified as consumer goods under UCC 9-109 1 or equipment / motor vehicle under UCC 9-109 2. Grimes versus Massey Ferguson. Okay? And that case took place in Alabama. You can see that right here. Okay? So you can see that this applies from state to state to state. It doesn't change. Okay, every state's bound by the commercial code. Alright, now it says that under the UCC, there's a real distinction between goods purchased for personal use and those purchased for business use. Those two are mutually exclusive, and the principal use to which the property is put should be considered as determinative. Right? And this was James Talcott Inc. versus G. And this case here, it took place in California. Right? Right here. And right here. That was in 1968. So we can see as the years go on, it doesn't change. It still keeps going. Right? And it says the classifications in goods in UCC 9-109 are mutually exclusive. McFadden versus Mercantile Safe and Deposit and Trust Company. Okay, so we're seeing here that it doesn't matter what year, it's still applying. Here we go. This one's in 1971. Okay. And I believe this one took place in Maryland. So here's another state where the ruling held that way. Alright? It says the classifications of goods, again, under UCC 9-109, is a question of fact. Well, what's the fact that they're questioning? The fact they're questioning is, do you use it commercially, or do you use it for your own personal family, in which case then it becomes consumer goods. Okay, household goods are consumer goods, guys. Alright? And it says the definitions of goods includes an automobile. Henson versus Government Employees, Finance and Industrial Loan Corp. There's your proof right there all of this, applies in every state. And this one's in 1974, so again, we're getting even closer to our time and date. Okay, I was a little kid when this one was done. And it says the term household goods includes everything about the house that is usually held and enjoyed therewith, and that tends to comfort and tends to the comfort and the accommodation of the household. Law will versus law will, right? This one took place in Arizona, guys, right here. Okay. So you can see that this doesn't change. It just keeps going and going and going, on and on and on. Now all these lawyers say, oh, yeah, these guys are sovereign citizens. They don't have the right to travel. But what you got to understand is that we're talking about what the law says. And I'm going to show you as we get down here, what the law says falls right in line with these rulings. Okay? I mean, up there we already showed you that the Indiana law says that a consumer good is the stuff that's used primarily for the house, for the family. Right? So, as you can see, it doesn't get any further, any less than that, right? And it says bequests of such household goods and effects include not only household furniture, but everything else in the house that is usually held and used by the occupants of a house to lead to the comfort and accommodation of the household. Okay? Mueller versus Probate Court of Ramsey County. And this, I believe, was in Minnesota. Okay? So, as you can see, it doesn't change. It just keeps going. Okay, now, this is a section out of you folks as Arizona. This is a part out of your Constitution, right? Out of your state Constitution. It says, all household goods owned by the user thereof and used solely for a non-commercial purpose shall be exempt from taxation, and such person entitled to such exemption shall not be required to take any affirmative action to receive the benefit from such exemption. Arizona Constitution, Article 9, Clause 2. Okay, now stop and think about that. Because what is it when you go get license plates? Alright? When you go get a license plate, that's an excise tax. Right? In other words, they're charging you for a commercial use, because that's the only thing that they can lay an excise tax on is commercially used property. It's the same with your property tax. Okay. Now, here's another section of constitutional law. There is tons and tons and tons of constitutional law, guys. And we should be learning it and knowing it. Because I'm telling you, we have really allowed ourselves to be abused by those in power. We've become ignorant to the facts. Matter of fact, if you go look at my page on Facebook, you will see a video where they're now talking about the fact that the reason Hillary Clinton didn't get arrested for the laws that she broke was because Bill Clinton threatened to tell all the secrets about those who were diddling little kids and the rest of the stuff that they've been doing. Alright? Now this is 25 Am Juror first. In other words, some of the first constitutional law ever made, guys, right here. Section 260. Moreover, a distinction must be observed between the regulation of an activity which may be engaged in as a matter of a right. Now remember, you have the right to travel. Okay? And one carried on by government sufferance of permission. Davis versus Massachusetts. Right? Now, what we've got right here is one can say for certain that these regulations are impartial, since they are being applied to all, even though they are clearly beyond the limits of the of the legislative power, right? It says, however, we must consider whether such regulations are reasonable and non-vocative of a constitutional guarantee. And travel is among the people's constitutionally protected liberty. As one of their constitutional guarantees, those who have the right to do something cannot be licensed for what they already have a right to do. As such, a license would be meaningless. And that was City of Chicago versus Collins. Now remember, they've told us that we're all crazy and we just don't understand the law and all these excuses that they've told us, and just bald-faced lied to the public, called people sovereign citizens, said we was a threat. People have gotten a shot over this, folks. These people should be held and tried for accessory to murders, because they made these poor cops out here. Some of these cops, I mean, I don't believe that all cops are bad. I'm sorry, I really don't. But if these guys are told that we're just crazy and that we're a threat and that we're going to kill them or we're going to do something to them, and then they're walking up and finding out that here's this guy standing there saying, well, I don't need a driver's license, and they don't understand because they've been lied to about what the law says. And then on the other side of that spectrum, they've been lied to again by these judges and these lawyers, and told that this guy's a threat, that he's liable to kill them. And suddenly these guys go into panic mode because they think they might have a psychopath sitting there. Right? They think they've got one of these quote-unquote sovereign citizens, which is an oxymoron. It doesn't exist. But if you want to talk about the idea of a sovereign citizen, let's think about this. If we're the ones following the law, and the judges and the lawyers are the ones lying about the law, then they're the sovereign citizen. They're the threat. Isn't that an interesting concept? Okay. And then we've got some more constitutional law. Again, Section 202, page 987 of 16 CJS, which again says the right of the citizen to travel upon the public highway and to transport his property thereon by a horse-drawn carriage, wagon, or automobile. Again, we have automobile. It's not a mere privilege. It's not a privilege, guys, which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and the pursuit of happiness. Okay, so now we know that these constitutional guarantees are here, and it goes on and on and on, all the way down through here, right? And here we have the constitutional Article 1, Bill of Rights, Section 1 for Indiana, inherent rights, right? And it says, we declare that all people are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Well, this right here, this constitutional law up here, says that traveling in your automobile is part of your liberty. Right? And we go through the same thing here. An 11M juror. First, Constitutional Law, Section 329, page 1135. And it says, personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint, unless by due process of law. Okay, here we are again with the due process of law. How many people are they taking into jail right off the side of the road when due process of the law only happens in the courtroom? That's an unlawful arrest, folks. Okay, unless that person has showed a clear threat of harm to the other people around them, or there's a clear intent that that individual means to do harm, that that man or woman means to do harm, then they're not following due process of law. All right? And for those of you who want to see these documents, many of them is posted on my Facebook. I'll try to put a link on the YouTube channel with this video so that you can see all of this stuff I'm talking about. All right? And it says, generally, 7M juror 2D, more constitutional law, subsection 9, automobiles and highway traffic. It says, ordinarily every traveler has an equal right in the highway and every part thereof with every other traveler. The public is entitled to the full and free use of all the territory embraced within the public roadway. All right, now stop and think about this. You're entitled to the full and free use. If you have to pay an excise tax, put a plate on your vehicle, insure it, go pay for a driver's license, is that full and free use? Or are you being charged to use what the law says you have a full and free use to? Now, this ain't my words. This is what the law says. Now, are we a nation of laws, or are we just a bunch of crooks like Hillary Clinton and the rest of these guys in Congress? And I don't want to single out just Hillary, because I'm going to tell you she's not the only crook we got. They're all crooks. We don't have one of them in office, whether it's state or federal, that has an honest bone in their body. And I don't believe that any of them holding office care for America or the American people. They're only there to get rich because of all the backdoor deals and all the crap going on. They don't give a damn about America. Matter of fact, I'd tell you that most of them hate America. And I would tell you that every judge that I've ever dealt with has shown me without a doubt that they hate America and that they hate the people. But that's another topic for another time. Okay. Now, we went through all this. We've shown you that through the constitutional law, there's no doubt you have a right to travel, and that you have a right to do it without paying for a bunch of crap. All right? So let's go into what they say a driver's license is, right? And this is how we're going to find the intent of the law as to who it applies to. Here below, the state denotes a driver's license as a commercial entity, as one who is employed commercially, right? This is a law that requires you to have a driver's license. IC 9-13-2-2-29. What's it say? Commercial driver's license. And here we go. It says Section 29, Commercial's driver's license, has the meaning set forth in 49 CFR 383.5. Now, isn't it interesting, folks? This is federal law right here that they're citing. But yet, if you go to a lot of these judges here in the courts in Indiana, they're going to tell you that they don't honor what the federal law has lined out. But they're using it in the code, telling you that's what it means. So, in order to know what it is and what it means, we've got to go down here to 49 CFR 383.5, just like what they're saying up here, right? And it tells you commercial driver's license, CDL, means a license issued to an individual by a state or other jurisdiction of a domicile in accordance with the standards contained in this part, which authorizes the individual to operate a class of commercial motor vehicle. Now, if a driver's license is there for commercial motor vehicles and it don't include anything else, there's an old maxim of law found in 11 CO 58 which says the inclusion of one excludes all else, right? So all they've said that this includes is commercial motor vehicles. Well, that don't apply to your automobile, does it? Because you don't drive commercially, you don't get paid. That means a driver isn't even what we think it is. And we'll see that a little later on. Okay? Nowhere else is a driver's license defined. Does there exist another definition? Not unless one's being hidden by the state. Right? So here we go to IC 913-2-29.5. Commercial's driver's license learning permit. Now this is what we go make our kids get. Every time when they hit 15 years old, they got to go get that permit and start learning, right? So, under this little ordeal, right? And here's all the little laws that go with it. But if it's a commercial learner's permit, we already know it falls in the same category as this for the commercial driver's license in 383.5, 49 CFR. So it's clearly commercial, right? And here's the Indiana code 924-6-0.5. Again, commercial driver's license. Okay, and it's to what? Operate a commercial motor vehicle. Only when accompanied by a person who holds a valid commercial driver's license. All right, are we seeing a key here to all these? You see where commercial, right? So anybody who tells you that the code doesn't define driving or the driver's license as a commercial activity, we can say right here without a doubt that they're lying to us, right? So we know that this is all about the commercial driver's license. All right, so we know what a driver's license is. We know it's defined that it's for commercial motor vehicles. So we need to see what a commercial motor vehicle is, and we've already established that yes, the state does use the federal definitions, right? So we got to go to Title 18, Section 31 definitions, and look at what is a motor vehicle. Okay? It says a motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes. Did you guys just catch that? What's that say? And used for commercial purposes. Words, terms, and phrases, guys, they all have a meaning. Okay, they've all been assigned a meaning. They may have hid them away from you, but they all have a meaning. Okay, so now we're going to have to find this term used for commercial purposes to understand what a motor vehicle is. And it says that it's used for commercial purposes on the highway in the transportation of passengers and property or cargo. Well, already it sounds like they're hauling somebody, right? Okay, another key word here is the word and. The word and means there's a requirement to something being a motor vehicle. It means it's required, it's not optional. They have to show a commercial use before they can say it's a motor vehicle. Okay, the word and in law means there is a requirement. So we must see the term used for commercial purposes to get the true intent and force of the law. Right? So again, we're at Title 18, Section 31, definitions. Subsection 10. Used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fair fee, rate, charge, or other consideration or directly or indirectly in connection with any business or other undertaking intended for profit. Okay? So now we can see that you're getting paid. You're a paid driver, right? So we see that the law has a clear commercial interest that's intended for profit. Okay? But we got to look up some more definitions of the words to get its true meaning. So here we're going to start with what a driver is, as well as what a driver's license is and who must have it, right? The object of a license is to confer a right or power which does not exist without it. Okay, we already know we have the right to travel. So a license can't be for someone who's traveling in their private automobile. The people always retain the right to travel, so the license couldn't be for the people traveling, as traveling is a liberty and there is no right or power to confer. Right? The people, however, do not retain the right to drive, which is a commercial interest. Here, a license is to confer a right or power in commerce, which does not exist without it. Now we will examine what a driver is by law, and keep in mind the oldest of maxims. The inclusion of one is the exclusion of all else. Right? So here we go, Drivers Black's Law, 3rd edition. It's one employed. Okay? Again, we're talking about somebody who's being paid. And what are they doing? They're operating a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or bicycle, tricycle, or a motor car. Right? Now, here we see pretty clearly that a driver is one employed as a driver, operating for some fair fee or wage. Right? We know that this doesn't apply to those who are just traveling in a car because they're not being paid. Now, the courts have been pretty crystal clear that the people traveling cannot be considered a driver. Right? Now, this is in statutes at large. Statutes at large apply to every state. They have to give full faith and credit to it. Okay? Article 4 of the Constitution requires that each state gives full faith and credit to all other states' laws. But more importantly, statutes at large are laws that have been set into cement. They don't get to change it. Period. Right? It says the words operator, owner, driver shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. Right? And that's found in Chapter 412, page 83 of the Statutes at Large for California. It says no one. Now, all of us, we can clearly see that there's a commercial aspect to the driver's license and to what a driver is, right, in the Indiana Motor Vehicle Code. And it's that way for every state. If you go through and you read your stuff, you'll know, right? And as we go on, you see that a traveler is just one who passes from place to place, whether for pleasure, instruction, business, or health. From one definition to the next definition. Now remember, these are 3 editions apart, but the definition doesn't change, right? And it says that in CBNS 429, right, for Walling versus Potter, 35, and this was in Connecticut. It says the term is used to designate those who patronize inns. The distance which they travel is not material. Okay? In other words, it doesn't matter if you're going from Indiana to California, or if you're only going to the local grocery store. It does not matter how far you're traveling in that car. The police have been very ill-informed about what your rights are under the law, and because we took other people's statements as factual that, hey, we had to have a license, we got to do this, we got to do that, and we didn't go and check it out for ourselves, we ended up getting ourselves into a pickle and started paying for stuff that we didn't have to pay for. Started going into a big mess, right? And here again, you can see that in 25 Amdura First Highways, section 427, page 717, a traveler is defined as one who passes from place to place, whether for pleasure, instruction, or business. Now that's constitutional law, guys. It doesn't change, right? It's set in stone. So when somebody says that, tells an officer they're traveling, that doesn't make them a sovereign citizen. That makes them somebody who's obeying the law. It's just that simple. So let us turn our attention here, guys, to a motor vehicle and the requirement of registration so that we know the intent and force of the registration laws, right? Now in IC 918-21, right? One of the first things that we notice is what the requirements are for who's required to register. Right? And it says registration, state residence. Pay attention to this word residence, guys, because you're going to find out that you're not a resident either. Right? It says section 1, A. Okay? And it says a person must register all motor vehicles owned by the person that, now we've got some requirements to meet. 1, are subject to the motor vehicle excise tax under IC 665. Right? And the second requirement is that that motor vehicle is going to be operated. Well, we've already established up there that operation of any motor vehicle is a commercial activity. Right? 2B says a person must register all commercial vehicles owned by that person that are subject to the commercial vehicle excise tax under IC 66-5.5, right? Which are not subject to the proportional registration under the International Registration Plan and will be, again, operated in Indiana. Right? So there's no doubt here that all of this goes back to a commercial use. Okay? But just to make sure, and so we can prove to the courts, we got to go look at, first off, IC 6-6-5 and see what motor vehicle is required to be registered under the excise tax. Right? Which ones are subject to it? That's one of the most important things that we need to go do, because we don't know unless we used to go and look, right? And we've spent generations taking other people's word, and we now see that those people who told us we had to do this were wrong. Right? Now, it says a person must register all vehicles owned by the person no later than 60 days after becoming an Indiana resident. Now, that too is a requirement. They've got to do it within 60 days after they become an Indiana resident. Right? So we're going to have to look at what an Indiana resident is a little later, because that too is a requirement. Okay, and it says, except as provided in subsection F, an Indiana resident must register all motor vehicles operated in Indiana. Alright? In G, it says an Indiana resident who has a legal residence in a state that is not contiguous to Indiana. Now, are you catching that? Not contiguous to Indiana. Now, some of you remember when I did my earlier video when I showed you the definition of resident in Pennsylvania. Okay? And it said there that you had to have a legal address in 2 or more states to be considered a resident. Right? In order to be considered a resident, you had to have a legal address in 2 or more states. Right? You needed a legal residence in a state that is not contiguous to Indiana. That means it's not inside Indiana, not within the Indiana borders. Right? May operate a motor vehicle in Indiana for not more than 60 days without registering the motor vehicle in Indiana. So look here, guys. Even if you are a resident, you still have 60 days from the time you bought it to register it. Okay? How many of these guys are they impounding their car right on the side of the road? Because they're saying, oh, your paper tag's expired. Well, right here, they have 60 days. Most anybody who goes to a car lot, they know that that paper tag's only good for 30 days. And people rush and strain their bank accounts and everything to get a plate, when by law they still have another 30 days before they have to register it, even though the paper tag's expired. Right? Now in H, it says an Indiana resident who has a registered motor vehicle in Indiana in any previous registration year is not required to register the motor vehicle. Is not required to pay the motor vehicle excise tax under IC 6-66-5 or the commercial vehicle excise tax under IC 66-5.5. Now look, an Indiana resident who has registered a motor vehicle in Indiana in any previous registration year. Right? Yet what are you doing every year? Right? What do they do to you every year? Every year you go back up there, they give you a new registration and a set of tags. And that right there says you're only required to register it the first time. So now we're getting a picture of just how big of crooks these guys are. Right? Okay? And now we're going to go into a few little exemptions here, right? And it says that under IC 665.5 on the Motor Vehicle Code, and is exempt from property tax on the motor vehicle for any registration year in which the Indiana resident is an active member of the Armed Forces of the United States and assigned to a duty station outside Indiana, and 2, the motor vehicle is not operated inside or outside Indiana. This subsection may not be construed as granting the Bureau authority to require the registration of any vehicle that is not operated. Now, isn't that interesting? there's an entire section, an entire paragraph of the law which says that they don't have the authority to require the registration of every single vehicle. Right? So this is an exemption, isn't it? And what's it required upon? It being operated. In other words, does it have a commercial operation? Are you making money from it, right? So, right here, we're going to go back and note that IC 918.21 only requires registration if the vehicle in question falls under IC 665 or the commercial vehicle excise tax under IC 665.5, and here in IC 665.5-1, here's where we'll find a clear definition under Indiana law of what a motor vehicle is, right? And it says there's a requirement of an Indiana resident who has a legal residence in a state that is not contiguous to Indiana. In other words, there's some other state involved in this deal. You've got another legal address someplace else other than just here. All right? So, we find out that an Indiana resident is described here in IC 9-13-2-78. Alright, so let us take a look at some of these laws, guys, and we'll discover the intent of the law, and then we'll know what the force of the law is. Although as of so far, we already know that it has a clear commercial intent for anybody who operates a motor vehicle commercially with the intent of being paid, which means they're operating for hire. If you're not operating for hire, it doesn't apply to you. It has one other requirement, right? The vehicle's operated. So, we stated that if the vehicle's not operated inside or outside Indiana, the subsection 2 may not be construed as granting the Bureau authority to require the registration of any vehicle that's not operated. Alright? We've already stated that there's a clear exemption. What is an exemption? IC 6-1.1-1-6. Exemption means a situation. Now notice it doesn't dictate solely about whether or not it's a car. It talks about a situation. So the situation, which means it's exempt, may not even apply to how that car looks, how it's propelled, how it runs, any of that. Right? But an exemption means a situation where a certain type of property or the property of a certain kind of taxpayer is not taxable under this article. Now, how about that? They're telling you that there might be an exemption, that you don't have to pay that excise tax. Alright? So now we know an exemption does exist. And at this point, the term operated can only have one logical conclusion in its meaning involving the commercial operation of a motor vehicle for profit or for hire. So we've got to examine IC 665 to see what it is, because that's one of the requirements, remember? What's the first thing? The first sentence in IC 665 says, the owner of a commercial vessel is liable for the tonnage tax imposed on it. Right? Each year a commercial vessel owner shall, when he files his tonnage tax return, pay the state the total amount of tonnage taxes which he owes. But this is only for commercial vessels. Well, if you've got a commercial vessel, you're making money off of that thing. You're getting paid to transport goods or people for some fair fee or wage. Right? Now this don't count you guys who are driving back and forth to a job on a construction site. This again does not apply to you. Not unless you're actually purchasing the materials and getting paid to haul the materials to the job site. Alright? Now, this statute clearly pertains to the commercial use of a vessel, and therefore there can be no other application. And to apply it differently would be a fraud upon the court, right? Okay, the commercial vehicle excise tax under IC 665.5, is self-evident in its intent. Just in its name, it's self-evident. Right? It says any commercial motor vehicle. Alright, this clearly defines a motor vehicle in Indiana as commercial. And it's the same in any other state, right? So, under IC 665.51, it says, unless defined in this section, the terms used in this chapter have the meaning set forth in the International Registration Plan or in IC 665, the Motor Vehicle Excise Tax. Okay, now, the International Registration Plan is only for big trucks and commercial vehicles which are of a weight of 10,000 pounds or more, right? But they're telling you right here that if it's defined in this section, it has the meaning set forth in those two codes, right? And it says definitions set forth in the International Registration Plan as applicable prevail unless given a different meaning in this section or in rules adopted under authority of this chapter. This chapter, guys, only this chapter dictates what a motor vehicle is. Right? And this is a section of the chapter that tells you what the meaning is. And it says the definition in this section apply throughout this chapter. As used in this chapter, base revenue means the minimum amount of commercial vehicle excise tax revenue that a taxing unit will receive in a year. And it says, as used in this chapter, commercial vehicle means any of the following. An Indiana-based vehicle subject to a portion registration under the International Registration Plan. A vehicle subject to a portion registration under the International Registration Plan and based and titled in a state other than Indiana, subject to the conditions of the International Registration Plan, right? And it says 3, a truck, road tractor, tractor trailer, semi-trailer, or truck tractor subject to registration under IC 918. Well, didn't we just go under that? Right up here? Right? And we read all through what IC 918 required, right? Now remember, right up here, under C, right? What'd it say? A truck, road tractor, tractor trailer, semi-trailer, or truck tractor subject to registration under IC 918. And this says that anything in C, as used in this chapter, means any of the following is a commercial vehicle. So if it's got to be registered under IC 918, it's a commercial vehicle, isn't it? Doesn't apply to your personal automobile, does it? Right? D, as used in this chapter, gross weight means the weight at which a vehicle is registered with, right? By the Bureau or the International Registration Plan. Is there any doubt at this point as to who has to register and plate their cars? Now see, here in Indiana we used to have a plate that you could go get, and it was called a restricted commodities plate. Well, as soon as everybody started digging into stuff and learning, allegedly, according to the BMV, they will not hand them out anymore. They're saying that our senators withdrew those plates. So if that's true, and somebody gets killed as a result of people not being able to get those plates anymore, because some cop thinks they are a, quote, sovereign citizen, our Indiana senators are now liable for the death that they caused. And hopefully some of you will call them and make them aware of this. Right? So everything from C on down is a commercial motor vehicle, right? And it says, as used in this chapter, owner means the person in whose name the commercial vehicle is registered under IC 918. So look, once you've registered this thing, you've now told them, hey, I'm operating in commerce, and you have a right to stop me, detain me, harass me, screw with me all you want. Okay? So, as we scroll on through, because we now know that it's without a doubt that it has to do with commercial vehicles. And as you can see, it's going back here, giving you the meanings of the various vehicles under IC 913. Remember, C up above said everything that followed was a commercial motor vehicle, right? A road tractor, semi-trailer. Tractor has a meaning set forth in IC 913 2-180, right? A trailer, a truck, tractor. As used in this chapter, vehicle means a motor vehicle. So whenever you see the word vehicle in the Title IX Motor Vehicle Code or in the Excise Tax Code, you now know that they're talking about a motor vehicle. And it says, a trailer or semi-trailer subject to registration under IC 918 as a condition of its operation on public highways pursuant to the motor vehicle registration laws of this state. Now, did you guys catch that? Vehicle means a motor vehicle. It says a trailer or semi-trailer subject to registration under IC 19 as used as a condition of its operation on the public highways pursuant to the motor vehicle registration laws of Indiana. So, who's required to register here? Only vehicles such as semis or motor vehicles that are used in the operation, in a commercial operation. Now, this would be a taxi cab, because that taxi driver, he's receiving a fare fee, wage or rate to transport somebody from one point to another. Okay? Now it says, note, IC 66-5.5, section 1, subsection C. Says, as used in this chapter, commercial vehicle means any of the following. Okay, this covers all of Title IX. We've seen that. They were quoting the sections of Title IX, telling you what cars were required to be registered. Okay, it says these statutes clearly outline all commercial vehicles. If an automobile isn't used in a commercial nature, then the automobile or truck, as long as it's under 10,000 pounds, remember, there's a weight limit as well, is exempt as consumer goods from licensing and registration. Remember the above maxim. The inclusion of one excludes all else. 11 CO 58, right? So now we know that these statutes are commercial in nature. Most people don't operate an automobile or a truck in a commercial nature for profit. So people's private automobiles are used as household goods, as a convenience of life to travel to and from work, for earning a living, groceries, etc. All right? There's no doubt about all this. We know it. It's all right there in the law. We're not stupid. We can read this and understand it just fine because we've gotten the definitions that they gave us. Right? Now the following constitutional law makes it clear in what vehicles can be registered. Right? And it says, excuse me, sorry about that. That A shouldn't be there. It says 7 Am Jur. 2D subsection 17. A state preempted from establishing its own standards. It is not preempted from enforcing the federal standards. Federal standards are all commercial in nature. Right? And this clearly shows the state is bound to the meaning. In other words, they've got to obey it. It's not shall don't mean may. It means they have to. Period. They have to obey the definition in Title 18, Section 31, which we seen earlier defined a motor vehicle as being used commercially. And we'll examine this again later. Alright? So now we know that there's a preemption that exists on the states here in 7 Am Jur 2D subsection 17. So let's see what that is. Right? Seven Am Jur 2D subsection 17. Automobiles and highway traffic. Preemption of state and local regulations. Right? It says the Motor Vehicle Safety Act 28 does not generally preempt the field of regulation of motor vehicle safety. 29. But it does preempt state standards relating to the same subject that are either more or less stringent than the federal standards. Okay, so if it preempts the state from setting its own standards relating to the same subject, and all the federal can do is regulate the commercial use on the highway, then now we see this is all the state can do. Because they're bound to the same limit that the federal government was bound to by law. It's a pretty interesting thing, isn't it, guys? Kind of makes everybody wish they'd read stuff instead of been gluing their eyeballs to the damn TV set, right? And it says only state statutes that conflict with federal safety standards are preempted. So in other words, if they try to make it apply to something outside of what the federal safety standards say it can be applied to, they can't do it. They don't have the authority. Okay? Now, it says, moreover, while a state may be preempted from establishing its own standards, it is not preempted from enforcing the federal standards. Right? Thus, federal safety standards on motorcycle helmets do not preempt state laws requiring motorcycle riders to wear a helmet. But you got to remember and look at what is a motorcycle, right? Because again, it's only a motorcycle if what? It's being used commercial. Otherwise, it's part of your consumer goods. And all that crap for the motorcycle laws no longer applies. It falls away. Right? And it says, but the state cannot prescribe helmets that differ from those in the federal regulations. Right? So even if they could force you to make a helmet, they can't make you wear one that differs from the federal regulations. So if the federal regulation says all you got to have is one that covers the very tippy top of your head, that's all you got to have. Okay, state laws that are requiring proof of compliance with federal standards before automobiles not originally designed for the United States market may be licensed and registered are also not preempted by federal regulation, right? So it's clear that states are bound by the federal regulations as to who is and isn't required to have a license, plates, and insurance, meaning that the following applies, right? Transportation 49 CFR 390.3, general applicability. Subsection F, exceptions. Unless otherwise specifically provided, the rules in this subsection do not apply to the occasional transportation of personal property by individuals not for compensation nor in the furtherance of a commercial enterprise. Right? It says the exemptions provided in subdivisions 1 and 4 of this section shall not apply to a motor vehicle, motorcycle, or trailer other than a semi-trailer drawn by a tractor registered in this state which is operated on the public highways of this state to transport persons or property for hire or profit from one point in the state to another point in this state, or which is operated in doing any work performed under a contract for a public improvement. I get that. Any work performed under contract for public improvement. Well, that's the guys who work on the roads and our district buildings, all that stuff, right? That don't have anything to do with the guy who's privately contracting with Mary Jane across the street to re-roof her house, right? Because that's improvement of private property, not public. Right? And we see here that Indiana Interstate follows Federal Regulation Part 390.21. So this is Indiana saying they follow this, right? Interstate 390.21 pertains to all qualified vehicles as defined by federal regulations. So right here, Indiana abides and uses the definitions for what a motor vehicle is. Right? They're saying they abide by the federal regulations, period. And again, we're back to Title 18, Section 31 definitions, because it's part of the regulations for what is a motor vehicle. Right? And what did we figure out earlier as to what a motor vehicle was? Remember, guys? It was any vehicle that's used with the intent of profit. Right? You got to get some fair fee or wage out of it. And as we can see here in the law, it isn't a bunch of crazy guys running around saying, I'm sovereign and I have the right to do this. Okay? What we've got is a bunch of government officials who've lied to the American people, and even worse yet, who have been lied to by our own news media. Saying that we don't have the right to travel in our own private cars. Now, why do you suppose they're doing that, folks? Why do you suppose we're all being lied to like that? There's only one reason. What is it that anytime something dirty's going on, everybody says? Follow the money, right? Okay, so now we know that the issue here is about money. Think about how much money the state makes from all those cars that get registered. Okay? We've established very well what commercial drivers are those that operate a business upon highways and roads. In other words, semi-drivers, all that kind of stuff. We've established all this stuff very well, and it's all right there in the law. Okay, so the only remaining requirement that we have at this time is that of being an Indiana resident. So now we got to see what an Indiana resident really is under the law, because as we've seen so far, most of what we thought doesn't apply. Okay? So we go to IC 913-2-78. Indiana resident refers to a person who is one of the following: a person who lives in Indiana for at least 183 days during a calendar year and who has a legal residence in another state. You get that? A legal residence in another state, guys. Okay? It says, however, the term does not include a person who lives in Indiana for any of the following purposes: attending post-secondary educational institution, serving on active duty in the armed forces of the United States, temporary employment, other purposes without the intent of making Indiana a permanent home. A person who is living in Indiana if the person has no other legal residence. Well, look at that. So just living somewhere and you don't have a legal residence someplace else, you're not a resident. Now we know that you're a non-resident. A person who is registered to vote in Indiana or who satisfies the standards for determining residency in Indiana IC 3-55, right? A person who has a child enrolled in an elementary or a secondary school located in Indiana. Okay, and by the way, guys, if you go to this statute here, Indiana 355, it's been repealed. It's not even being used anymore. So, on 5, it says any person who has more than one half of the person's gross income as defined in Section 61 of the Internal Revenue Code, now we're talking about the Revenue Code, derives from sources in Indiana using the provisions applicable to determining the source of adjusted gross income that are set forth in IC 6322. However, a person who is considered a resident under this subdivision is not a resident if the person proves by preponderance of the evidence that the person is not a resident under subdivisions 1 through 4. Right? So they're talking about 1 through 4 up here. Right? From here to here. So if any of this up here, like this one here that applies to me, then you're not a resident. Right? So, now we're going to get into the reason as to why the definition is the way it is. Because most people are clearly a non-resident, unless the state claims proof of residence in another state and can put it on the record. Okay? Right here is why. It says, therefore, the U.S. citizens of the District of Columbia residing as a resident in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. That was in Wheeling Steel Corp versus Fox. Remember, the United States is a corporation. So any of the people who work for the United States are considered to be in the District of Columbia for all intensive purposes, right? Now right here, 25 Amjur 2D, this is your definitions and distinctions generally for residents, right? And it says non-establishment of domicile in foreign jurisdiction, 4 Amjur, proof of facts, 2D 595. Okay, and it says, as distinguished from a fixed habitation, residence generally refers to an attachment to a place that is temporary. Well, these senators who travel back and forth between, excuse me, between Washington, D.C. and the various states that they're representing, they would be considered temporary, wouldn't they? So that's why you see everything going the way it goes. It's an impermanent or transient condition. The term residence imports merely having an abode at a particular place, which may be one of several places where one is physically present from time to time. Right? This is constitutional law, guys. Pretty important to know this stuff. Right? So, as we go on down, we see that this just continues over and over and over with court case after court case. And it says, as to domicile by choice, see subsection 6. As to domicile of a particular person, see subsection 27. Right? But this goes on. It says domicile means a permanent place of abode, whereas residence is not necessarily permanent and may be at some place other than the place of domicile. Wright versus Gross, 229 Georgia. Okay? Now remember, guys, if you're going to go drive in your car without getting it registered, get a hold of these things and take them down to the police and talk to them and say, look guys, you've been lied to as to what the law means. Get your state statutes and everything. Go talk to your local police chief and tell him, say, sir, look, I'm not trying to break the law. I want to show you that I'm following the law, right? So that you can inform your officers that I'm not doing something wrong, because I don't want them to freak out and shoot me because they think I'm doing something wrong, right? You take all the precautions you need to take. Right? And it says the term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. U.S. versus Anthony. So remember, guys, we were taught all the way growing up through school to say that we were what? A citizen of the United States, right? Well, why do you suppose that they lied to us about who we were? Okay, the answer's simple. If you claim to be a citizen of the United States, all these rights that we've talked about that you have, all of them, right down from the freedom of speech to the right to use your property or even own property, you don't have it. You do not have it if you're a U.S. citizen. Everything you have at that point has been pledged to the federal government. Even though it's an unknowing pledge, you've pledged it. Okay? That's why all United States citizens have to pay the federal income tax. Because all United States citizens are employees of the federal government, whether they are working in the state government or the federal government. Because they are all part of the federal national government. which if you go to my page, you will find out that you do not have to pay the income tax. It's a bald-faced lie, right? And it says these rulings and statutes make it clear the resident or U.S. citizens or government employees who have no constitutional protections like the citizens of the several states. What are the conclusions of law? A commercial vehicle is a vehicle of a type required to be registered under this code. B. Passenger vehicles which are not used for the transportations of persons for hire or compensation or profit, and house cars are not commercial vehicles. C. It is held that a tax upon a common carrier by motor vehicles is based upon a reasonable classification and does not involve any unconstitutional discrimination, although it does not apply to private vehicles or those used by the owner in his own business and not for hire. And that was decided in Deser versus Wichita, and that was in Kansas. Okay, we've been through about every part of the state, right? Every state with all these different rulings. And it says this ruling is consistent with the undisputed fact that the classification of goods is determined by its primary use. Barron's Law Dictionary, 3rd edition, 1991, and not by the type of goods, including but not limited to vehicles. Right? And D, a vehicle not used for commercial activity is part of one's consumer goods. It is not a type of vehicle required to be registered under a use tax, paid of which the tab/license plate is evidence of receipt of the tax. Bank of Boston versus Jones, 4 UCC Rep. Right? It says, thus just self-driven vehicles classified according to the use to which they are put rather than according to the means by which they are propelled. Ex parte Hoffert. Okay? So it's all about whether or not that vehicle can be classified as a consumer good or whether it's equipment, which equals a motor vehicle under UCC 91092. Okay? If it's here under UCC 1091, it's consumer goods. It doesn't have a commercial use. It's not equipment. It's not required to be registered. And I will challenge any lawyer to prove me wrong. I don't care if he's a constitutional law scholar. I don't care if it happens to be one of the judges of the Supreme Court of the United States. If they try to tell you anything different from this, they're lying. The law says they're lying in every aspect. They're doing this because they get to make money off of you, off of that Form 205 and 206 that I mentioned earlier, when they get to drag you into the court for not wearing your seatbelt and all these other things. Now, thankfully, there is a law that allows you to challenge the subject matter jurisdiction of the court, in which you tell the judge quite plainly, Your Honor, he's brought forth a false claim. I was not operating for hire. Now the judge will know what this means. The cop may not, but the judge will. Now the cops will, if we work with the police and we take all of these things to the police and educate them before we go out on the road so that their people aren't going crazy trying to kill us, thinking we're one of these sovereign citizens, which actually applies to the lawyers and judges because they're the ones who aren't obeying the law. Okay? So we've learned that this is reiterated in IC 26-1-9.1-102-23. It says consumer goods means goods that are used or bought for use primarily for personal, family, or household purposes, right? We've already seen that this includes automobiles. The appropriate filing place for a motor vehicle turns upon the classification of the collateral as consumer goods or equipment slash a motor vehicle, which equipment, motor vehicles, are required to be registered at the BMV or under the International Registration Plan, either of the two, right? But these two places are only required for commercial vehicles, okay? There exists no requirement to register consumer goods, which we can find in the law. The Uniform Code classifies goods as consumer goods if they are used or bought for use primarily for personal, family, household use. Right? We know that. Household purposes, that's it. If it's a household purpose car, you don't go driving around and hauling people and getting paid to take people from here to there to yonder. You're not a commercial driver. Therefore, you don't need a driver's license, license plates, tags, insurance, any of that. It says most people are clearly a non-resident unless the state claims proof of residence in another state on and for the record due to the temporary nature of a resident as described in IC 913, right? So we know that it's all about a temporary right? We know it's all about a temporary use. That's the bottom 9 yards of it. Or a temporary dwelling. In other words, if I lived in Ohio and I came over to Indiana and I had a legal residence here and I stayed here for more than 60 days but kept my legal address in Ohio, I would have to register as a resident. Because now I become involved in commerce. Because I'm over here for some sort of vacation, I'm buying goods, I'm doing things. Y'all see how that works? Now, hopefully this helps all of you understand what's being done to you. And hopefully this video works out good enough for you to understand what has happened to you. So, I appreciate you watching. And let me know if there's something that